It's not only about the business lounge, not only about who you know, the invites to private flights, the yachts, or the views. Not about the late nights and early mornings. It's not always about closing the deal or soaking up the applause. No, none of it really matters without those that matter most. You see, it's not about what you do, but who you do it for.
Welcome, ladies and gentlemen, to 30 years of celebrating democracy in South Africa. And I don't need to tell you more. You are at the great University of Johannesburg, where I have got a panel of distinguished guests tonight that will share insights for the past 30 years that has happened in the legal industry and specifically our faculty. But without further ado, I want to bring in our Executive Dean, Professor Kathleen van der Linde, to officially welcome us to the event. Over to you, Prof.
Good evening, ladies and gentlemen. It's my pleasure to address you this evening as Acting Executive Dean of the Law Faculty. I have just discovered in the past couple of minutes that some events, I thought it was all virtual, and then I discovered that I was actually supposed to be in Johannesburg. So thanks to modern technology, I can still speak to you. So it gives me great pleasure to welcome you to this event. A hearty word of welcome to each alumna and alumnus of this faculty who joins us this evening, either in person or virtually. Welcome also to faculty, staff and students, and of course a special welcome to our panelists who come to us from different branches of the legal profession. Advocate Mutemwa, Mr. Marais, Mr. Luthuli. Thank you for agreeing to do the hard work this evening. I'm looking forward to the insights that you will be sharing with us under the facilitation of my very energetic colleague, Mr. Elton Hart, who I'm sure will make it feel less like hard work and more like fun. The topic of our panel discussion is a very important one now that we have just entered the 31st year of democracy in South Africa. Reflecting on justice and democracy from a legal perspective is not simply an exercise in history. Reflection is an essential part of planning for and working towards the future. The American educator John Dewey said, "We do not learn from experience, we learn from reflecting on experience." The Law Faculty of the great University of Johannesburg treasures its relationship with alumni, and we are very proud of your successes. We measure our societal impact also through the difference that each of you are making towards solving the problems of our times and through your efforts to ensure a better future in which justice thrives. Ladies and gentlemen, please enjoy this opportunity to listen to and engage with this panel. Before I hand over back to Mr. Hart, I would just like to thank our sponsors, Standard Bank, and because I know that Mr. Ledwaba won't be thanking himself at the end, I think I should also thank him in advance. Thank you very much, and over to you, Mr. Hart.
Thank you, Professor, and thank you for once again allowing us within the faculty to actually do and display the greatness of the University of Johannesburg, and specifically the Faculty of Law, or as we would call the Orange-Red Army from the 7th floor. Now, without further ado, on my right-hand side, we've got a panel, and I promise you, a panel loaded. Loaded, not like a KFC Boxmaster, but loaded like the University of Johannesburg can never, ever do it better. So, guys, without further ado, I would want to go directly to my right, because I have so much respect for ladies first. It's the distinguished Advocate Deborah Mutemwa. She started off her illustrious career at this very same great University of Johannesburg, where she graduated and further on went to Weber Wenzel, where she did her articles. And later on, she became not any judge's clerk. She became the judge's clerk of Judge Sisi Kampempe. And we know she's an Iron Lady. But next to me, Miss Deborah Mutemwa. Not just any Miss, she's a Miss Advocate Deborah Mutemwa. So over to you, Miss Mutemwa, and grace us with what you have to offer in this journey of 30 years.
Thank you so much, Mr. Hart. That's a very humbling introduction. And I just want to take an opportunity to thank the Faculty of Law for inviting me, the UJ Alumni Office, the Acting Executive Dean, and all of the alumni that are joining us online. It's such a pleasure to be here at my alma mater, reflecting on 30 years of legal democracy. And for this discussion, I want to focus on transformative constitutionalism. The idea behind transformative constitutionalism is this: in order to pull the nation out of the darkness of the past, we needed a constitution, a document through which an entire society could be transformed. And as we reflect on 30 years of legal democracy, I wanted to share some thoughts about how the Constitution has fared thus far in transforming and impacting society, and also reflect on what more needs to be done. It would not be an exaggeration to say that there are very few legal documents that have held as much weight as the South African Constitution. In many ways, it held the hopes and aspirations of not just the nation, but in some ways the world. The fight for freedom and democracy in South Africa is a matter that near the end took place on the world stage. And as we reflect 30 years after the fact, it would do us all some good to remember that before the Constitution was negotiated and agreed to, South Africa went through a long, sustained period of ever-increasing violence, including political violence, around the CODESA negotiations. What emerged from the CODESA process is this incredible document that we call our Constitution today. And it held the vision of what a free, fair, and democratic South Africa could look like. For the first time, equality between all people was recognized. The right to a basic education was guaranteed, and the right to social security was protected. This same document boldly declared that the Constitution is the supreme law of the Republic, and any law or conduct that is inconsistent with it is invalid. This doctrine of constitutional invalidity basically means that anything that is said and done that is not in line with the Constitution can be tested against it and declared invalid. But it is the courts, as the arbiters of legality, that must declare such conduct invalid. And time and again, our courts have done just that for some of our most fundamental rights. In the last 30 years, in fact, only 20 years ago, in Bear, the court declared that women can inherit assets from a deceased estate directly for the first time. Before this, only men had this privilege under certain legislation. In the last 10 years, our courts have declared that domestic workers, farm workers, who are legal occupiers of dwellings on farmland can make basic improvements to their homes without first fighting for permission from farm owners. A great victory for the dignity of the most vulnerable in our society. In Christian Education South Africa, the Constitutional Court case, in the year 2000, our court declared that a legislative prohibition on beating children in schools does not violate religious rights. And in 2005, less than 20 years ago, our courts extended the Commonwealth definition of marriage to include same-sex couples. In countless other cases, our courts have held executive power in check, a marked difference from the past where parliamentary sovereignty was the order of the day. And so, in many ways, our Constitution has delivered. It has transformed our society. However, the Constitution holds within it not freedom and democracy itself, but the roadmap to a free, fair, and democratic South Africa. A mere document cannot do the work required to achieve true freedom and democracy. The nation, and not just leaders, but ordinary South Africans, have to get to work. In his speech titled the spirit of liberty. Judge Learned Hand, an American jurist, lawyer, and judicial philosopher, ventured to describe the essence of freedom, and dare I say, democracy, as follows. What do we mean when we say, first of all, we seek liberty? I often wonder whether we do not rest our hopes too much upon constitutions, upon laws, and upon courts. These are false hopes. Believe me, these are false hopes. Liberty lies in the hearts of men and women. When it dies there, no constitution, no law, and no court can ever do much to help it. But when it lies there, no constitution, no law, and no court is needed to save it. And what is this liberty which must lie in the hearts of men and women? It is not the ruthless, the unbridled will. It is not the freedom to do as one likes. That is the denial of liberty and leads straight to its overthrow. A society in which men recognize no check upon their freedom soon becomes a society where freedom is the possession only of a savage few. This we have learned to our great sorrow. End quote. With that in mind, a question that I believe is worth reflecting on is what we as ordinary South Africans have done in the past 30 years to protect and defend this hard-won democracy. And while there are many legal victories that can be celebrated as we contemplate 30 years of legal democracy, one cannot ignore the fact that ours is a society that is not quite where it ought to be. We have one of the best constitutions in the world. However, that does not always translate to us having one of the best societies in the world. Why is that? I would like to suggest that this is because the law can only go so far and then no further. As we reflect on the shortcomings of our society in the face of 30 years of legal democracy, perhaps we should consider that democracy is not something that can be captured in any legal document. True democracy is won and maintained by the hard work and the undying hope of the people. Hence the definition of democracy, a government for the people, by the people. In 30 years of democracy, what kind of a society is being experienced by our most vulnerable citizens? In a concurring judgment written by Justice Froneman of the Constitutional Court of South Africa in Daniels versus Scribante, which had to do with the rights of domestic workers, security of tenure on a farm, Justice Froneman comments as follows. The Constitution affords us all the opportunity to attempt to develop a society where the injustice of the past can be addressed without the denial of the dignity, freedom, and equal treatment of all the inhabitants of this country. It is an opportunity that we dare not ignore. Thank you. Over to you.
Wow. It's like Advocate Mutemwa took me on a journey. I can listen to her the whole night. The way she was just engaging us, making me again journey down memory lane and think about what have we achieved, but what is there still to achieve. But we will leave it for the questions and answer session. Now I want to bring to you guys, I would want to put him in the caliber of a sniper, because he goes into the terrain where you deal with financial laws. He worked at Treasury. He's got years and years of experience. He's one of our own. He has done it on cyber law. He has done it on commercial law. But the best thing of it all is that he has the ability to appear in any court in this country, from a district, regional, high court. And when we talk about high courts, all the high courts in this country. Without further ado, my colleague, Mr. Albert Marais.
Thank you, Mr. Hart. Do you believe that respect has to be earned? Let's park that for a while. Allow me to give you some insight into the way that lawyers think, because I firmly believe that the way lawyers think is what keeps a democracy alive. I do not believe that respect has to be earned. The way a lawyer sees the world is, I respect you. I give you my respect. Here is my respect. Okay, if you do something truly atrocious, you will destroy that respect. But the starting off point, the rock solid foundation, is this mutual respect that we as lawyers have for one another. On top of that rock solid mutual respect, we have the freedom to differ about every single thing. And to keep a democracy alive, we have to nurture this ability to, on the basis of mutual respect, have the freedom to argue, to debate, and to differ. A democracy where people believe that in order to have respect for one another, in order to move forward and in order to cooperate, we all have to believe the same thing, is a dead democracy without anyone having realized it. The analogy of, very cruelly, dropping a frog into hot water and the frog saving itself by immediately jumping out of the hot water, it has the ability, it is strong enough, it can sense that there's danger, as opposed to a frog very cruelly and very slowly perishing in water that is gradually warming up to a point where the frog boils. Apologies for a very crass analogy of comparing a frog to a democracy. I personally would prefer my democracy and my frog to be alive. Thank you, Mr. Hart.
Thank you, Mr. Albert Marais, for sharing that analogy. And I was thinking where it was going, but I soon catch the drift. And he wants the democracy to be alive. And that's also how our constitution is written, that our democracy is alive. Now, without further ado, he's one of our own. He has mentored, he has lectured so many, and I think some of the panelists was even some of his students. And he decided now, I call that place the high school down the road. He decided to go and visit them because we're going to get him back. We are going to get him back. He is known as Professor Marius van Staden. He has mentored over 30 students in the LLM dissertations, modules. He has done a tremendous wealth of work in social and labor law, social security specifically. So he is a lawyer that has passion for the people, because you know, labor law, social security law, that's law for the people. Without further ado, I want to give you the 2019 recipient of the VC's most promising teacher, Professor Marius van Staden.
Thank you so much, Mr. Hart. Before I start, I would like to just say a word of thanks really to a colleague of ours that died a couple of weeks ago, Professor Rotenbach. Professor Rotenbach ignited a passion for constitutional law for so many people, I think even in this room today. I don't think that people would be aware of the profound impact that he has had on the lives of so many South Africans. As South Africans go about their daily lives, they may not be aware of the very influential nature of his work. He advocated for human rights in South Africa way before it was fashionable to do so and politically expedient to do so. So just a word of thanks to our former colleague. Now, when we speak about democracy, we have to speak about suffrage, the right to vote. I remember when I was very small, having to stay home at my grandmother's. I think my grandmother came to watch me and my sister because my mom and dad were working at a voting station. I was, I think, in grade 1 when we had our first democratic or universal suffrage voting in South Africa. And there's one image that still to this day stands out for me. I remember watching the 6 o'clock news as it was then. And I remember an interview with a very elderly lady who stood in a queue kilometers away from reaching the polling booth. And the journalist asked this lady why she didn't go to the front of the queue, because even then there was a system in place where elderly or disabled people could cut the line and go to the front of the queue. And the following words, which I'll paraphrase, has always remained with me. I remember her saying that for her to stand in that queue is the honor of a lifetime. It's something that she and so many people have fought for. Why would she leave that queue? It was an honor. It was a privilege to stand in that queue. And I think 30 years on, perhaps, we've forgotten a little bit about the severe degradation and abasement that South Africa has had in not being able to vote. So perhaps it's an opportune time, 30 years after our first democratic election, fully democratic election, to ask the question, who will not be voting in this month's election? My favorite philosopher, Marthinus, has highlighted that our greatest ethical duty towards ourselves is to become someone on which nothing is lost. I am afraid, however, that as South Africans, we have become obtuse to the fact that so many people still live in utter degradation and abasement. And something that I would just like to briefly touch on tonight is the abasement of especially undocumented migrant workers who so fundamentally contribute to South Africa's society but do not have suffrage. These workers, even though they contribute to our society, raise our children, work in our homes, and really are people that our society fundamentally relies on, will not be voting. And I think as South Africa reflects on 30 years of democracy, it is really something worthwhile to reflect on. We have to highlight the importance of ensuring that all individuals within South Africa's borders, regardless of citizenship status, have access to the substantive freedoms and opportunities necessary to live a dignified life. This includes the ability to work in safe conditions, receive fair wages, access healthcare and education, maintain social affiliations, and have a voice in decisions that affect their lives. But quite often, they do not have a voice in the decisions, not only because they can't vote in this upcoming elections, but also because with one phone call, they may be reported to the police and arrested because of their undocumented status. By recognizing their inherent human dignity and striving to dismantle the barriers they face in realizing their potential, I believe that South Africa can move towards a more inclusive and just society that truly embodies the spirit of democracy. Failure to consider the circumstances of indignity faced by the often overlooked population risk, perpetuating inequalities and undermines the nation's progress over the past 3 decades. I think that when we have discussions about decolonization of law and decolonization of society, it's so important to realize that the borders that exist within this African continent wasn't drawn by Africans. It was drawn by European aristocracy and leaders in the 1800s, something that African leaders of the time had no say in. African voices were not considered. Yet, those choices, those drawing of lines, continue to have such an important impact on the lives of so many South Africans today. So, I think we need to call attention to the ability of migrant workers to actually access core capabilities like bodily health, bodily integrity, emotions, practical reason, affiliation, and control over their own lives. Something that they are never totally able to do in a system which doesn't allow them to have a voice. Even where these workers lack formal political rights, migrant workers should still be able to live free from violence and discrimination, to access healthcare and education, to form social relationships and attachments, to think and reason, and to have a voice in the decisions that affect them at work and in their local communities. At the moment, they do not. Real substantive freedoms and opportunities depend as much, if not more, on formal legal rights. What matters is whether people in their particular social context actually have the ability to live flourishing lives, taking into account economic, social, and cultural barriers. This means paying special attention to marginalized and vulnerable groups who may face unique obstacles to realize their potential. So, while expanding formal suffrage is important from the capabilities perspective that our Constitution seeks to enable, it's not the whole picture. A just South Africa needs to be attentive to the substantive opportunities and quality of life of all who make up its society, including migrant workers. It must try to dismantle barriers and provide the material and institutional support people need to truly flourish and live with dignity, regardless of their voting status. In this light, I think there is a moral obligation on us for all South Africans to embrace an inclusive conception of social membership to our society, where all that contribute to our society are afforded core rights and opportunities as a matter of justice, even if some lack formal political power. It calls for policy and social imagination to support the flourishing of the country's full human diversity. Thank you, Mr. Chair.
There you have it. I told you, he is a man for social security, and you could hear it in the speech. He's always looking to protect the vulnerable, and that's what we sign up as lawyers for, and that's what I respect him for. But without further ado, I want to move to the next panelist. He carries a heavy surname called Luthuli, because we know Chief Albert Luthuli and his values. So that surname is not carried by anyone, not by anyone particular, but it's carried to that by Mr. Bongani Luthuli. Now, Mr. Bongani Luthuli is a very prominent figure. Why do I say he's a very prominent figure? Because in his short legal career, he has already risen to the level of judge of the Labour Court. Now, a Labour Court is similar to a High Court in South Africa. And for him to have made it thus far just says one thing: he should be brilliant. And I hand over to you, the brilliant Mr. Bongani Luthuli, or as people would refer to him, my Lord Luthuli.
So much, Mr. Hart. It is an absolute honor and a privilege to be back at home. It feels like a homecoming of some sort, especially the panel that constitutes some of my friends and colleagues in the profession. Allow me, moderator, to talk about, in my reflection, a reflection of the tension between the judiciary, the legislative, and the executive. How have the courts transformed as an institution from the epoch of parliamentary sovereignty that my colleague, Adv Deborah Mutemwa, spoke about, to the constitutional dispensation from the prism of the public and also from its relations with the executive and legislative arms of the state? Firstly, It was important for the judiciary post-1994 to reflect the large populace of our nation. Indeed, political litigants such as Steve Biko, Nelson Mandela, and Robert Sobukwe lamented that as political trialists, they did not have the confidence in the white courts. The transformation of the judiciary became an important project. Institutional transformation has been gradual but indisputable. In 1994, about 85% of legal practitioners in South Africa were white. The entire judiciary included only 4 Black and 2 female judges, both of whom were white. Instead of uprooting and replacing that judiciary, the Constitutional Assembly elected to retain judges appointed under apartheid to ease the transition. Accountability and the rule of law constitute the sharp and mighty sword that stands ready to chop the ugly head of impunity off its stiffened neck. These are the words of former Chief Justice Mogoeng for the unanimous court in the first paragraph of the Nkandla matter. Like all things in life, like the best of times and the worst of times, litigation must at some point come to an end. The Constitutional Court, as the highest court in the Republic, is constitutionally enjoined to act as the final arbiter on litigation. This role must not be misunderstood, mischaracterized, nor taken lightly, for the principles of legal certainty and finality of judgments are the oxygen without which the rule of law languishes, suffocates, and perishes. So reads paragraph 1 of Justice Kampempe's majority pen in the landmark President Jacob Zuma and State Capture Commission matter. In September 2021, the DA joined the chorus of politicians who criticized the judiciary when it alleged that the ANC withdrew its application to have the IEC reopen the candidate list registration process for the local government elections that were going to take place later that year because of a tip-off from the Constitutional Court that the poll would be delayed. The criticism against the judiciary started from the days of Julius Malema, then ANC Youth League president, defending Jacob Zuma, to more recent attacks by the tourism minister saying the judiciary is not untouchable. In defense of the judiciary, judges do not bring disputes to courts. Litigants must bring matters to court for adjudication. When litigants bring matters to court, one party emerges victorious. I'm reminded of the timeless word by my mentor, Justice Edwin Cameron, who said the following, and I quote, "The Constitution itself cannot save South Africa from crime, corruption, misgovernance, government inefficiency, and police brutality. What can save us is the Constitution in combination with the proud, deeply skeptical population together with principled lawyering," close quotes. This principled lawyering that Justice Cameron exhorts us about entails inter alia judges who hold true to their oath of office and the rule of law. It is important for the public to respect the judiciary as an independent third arm of the state. The former DCJ, Dikgang Mosneke, said in January 2017, and I quote, "The Nkandla moment presented that opportunity to interact with our people and to tell them about the legal, constitutional, and normative underpinning of public power and why we are duty-bound to deploy it honestly and effectively in order to produce good outcomes and to produce a just society," close quote. Judgments, therefore, provide a tool to communicate with the society and remind it of the conduct that is frowned upon. Remind society, as this judgment does, that everyone is equal before the law and that judges must dispense of their duties without fear, favor, or prejudice. Dean and John L. Komarofin, in their seminal work, Law and Disorder in the Post-Colony, define the concept of lawfare as follows. Politics itself is migrating to the courts. Conflicts once joined in parliaments by means of street protests, mass demonstrations, and media campaigns, through labor strikes, boycotts, blockages, and other instruments of assertion, tend more and more to find their way to the judiciary. Class struggles seem to have metamorphosed into class action, close quote. It's lawfare that has resulted in incessant attacks against the judiciary over the past 30 years, which in my view, from a diagnostic point of view, could stem from the judiciary as an institution refusing to appear before the TRC to account for its role in aiding and abetting apartheid. The question was whether this refusal was morally justifiable or not. The TRC condemned the refusal of judges to give oral evidence, and a possibility of a subpoena was considered. Unfortunately, it was not explored. The judiciary, I submit, missed out an opportunity to win public confidence and also to get a moral vindication from politicians as to the role it played, which could have been explained by the jurisprudence of legal positivism that prevailed at that time. This snubbing of the TRC has resulted in politicians such as Minister Linde Zulu labeling judges as being arrogant and not answerable to anyone. But this criticism, with respect, is unfounded. Judges carry out their functions publicly and express their opinions through their judgments. With hindsight, The refusal by the judges to subject themselves to the TSC was a correct one for the sake of the integrity of the courts. The tension between the judiciary, the legislative, and the executive is necessary for the democratic project. Politicians cannot be pleased with court outcomes, as that would mean that judges are at their beck and call. Politicians must just be content with judgments. No other statesman demonstrated this better than Nelson Mandela, who subjected himself to a subpoena by a magistrate and testified in the Sarfu matter brought by Louis Late. I close with the words of Justice van der Westhuizen, and I quote, "The law is indeed a powerful instrument in the hands of a very small group, privileged to have been educated and trained in it. It could be used to intimidate, oppress, and further marginalize those who are not as privileged as lawyers are, or to inform, educate, and empower, and indeed protect the people," close quote. I hope that we as lawyers use the law for the latter purpose. Thank you, and back to you, Mr. Hart.
Thank you, my lord, or as I would say, Mr. Bongani Luthuli, taking us on what we call jurisprudential gymnastics quickly in that speech, but also reminding us again between the workings between the various or different arms of government, which is important to understand as South Africa and as we journey on this 30 years into democracy with our courts. And as he rightfully pointed out, judges don't bring matters to court, it's people that bring matters to court. And this is one of the important things that we want to look at and also reflect on. And I can see that in the chats already, that the chat is buzzing. The chat is buzzing. And I would start off with Professor van Staden, because the very first question that was posed by Anonymous here in the group chat was, Professor van Staden, what's your view about the recent court judgments, which seems like they are politically motivated? That's the one question for Prof. van Staden. The second one is directed at Advocate Deborah Mutemwa to say, Advocate, in making sure that women has an interest in legal careers, what are the avenues that we can use to open doors for females in the industry? Then they have a question also for Mr. Marais to say, what is your legal journey? What actually sort of have directed you to move into forensics and going into investigations and that type of thing? I think this guy, because what he's saying that he's a personal follower of your work, and he wants to know what actually triggered you to move into that sphere of the work. Then what is the gains or the differences between before democracy and after? Did SA make progress since then? And that question is open for everybody. I think I would first want that questions out of the way before we journey into one, but I know there was one for Mr. Luthuli as well. I just want to find it and then I'll give it to you, Mr. Luthuli, so that you can specifically respond to that question, because the users, Mr. Luthuli, how do legal practitioners open up opportunities for young graduates regarding serving of articles and actually growing into the legal industry? And I know why that question is coming to you is because they see you look young, handsome, and yet they hear you are a judge of the labor court. So I would hand over to Advocate Mutemwa. She can start off with answering her question, and then we will give each of the panelists to answer. At least I pick one question for each one to actually engage the audience on.
Thank you to, I didn't catch the name, but for that question, I think it's vitally important to continue the conversation about female representation. And I say that with a smirk on my face, because you will notice that I'm the only woman on this panel, and I've made various comments about that. I think it's really important for us to recognize that just because the Constitution guarantees the right to equality doesn't mean we're there yet. And that is so much more true when we speak about gender equality and gender parity, particularly in the legal profession. We still don't have enough female judges. We don't have enough female advocates. We don't have enough female legal practitioners, lecturers, wherever you want to look within the legal fraternity, women are underrepresented. Now, as somebody who has spent my entire career in the legal fraternity, I cannot say that there are any particular bars to a woman being active in the legal space. You can study law, you can apply to work at a law firm. There's nothing systematic in the sense of, you know, you won't be rejected for being a woman. I think the challenge is when you get into those spaces. It's the attitudes of everyday legal minds towards women that makes it particularly difficult. And as I address this point, I remember, you know, the Convention on the Elimination of Discrimination Against Women. It's one of the only conventions in the world that not only expresses the legal rights that should be afforded to a specific group, but it also speaks about this concept of challenging cultural norms. And there are many, many cultural norms within the legal profession that need to be unraveled. And I think that as a woman, if you're looking to enter the legal space, first and foremost, do it. Secondly, be prepared to perhaps be the only one in the room. But more importantly, be prepared to be vocal about being the only one in the room. Be prepared to be vocal and to point out when there's a lack of female representation, because then slowly and surely, we will start to see cultural norms transform and change. I don't think that that is the whole answer, but it is an answer to that question.
Thank you, Advocate. Over to Mr. Marais, because I believe this person was probably one to journey your route to understand the legal journey you took to get you to where you are and your interest in the regulatory spaces.
Okay, first off, for anyone who wants to make contact with any one of us, you are very welcome to do so. Every member of the panel is very well represented on social media with contact details. Do not hesitate. When we talk about commercial forensic investigations, it's mostly a team effort. You need forensic accountants, you need computer information system experts, and you need a legal background to make all of that work, in the sense that you can successfully take a matter forward. If you don't know the rules, you cannot play the sport. Thank you, Mr. Hart.
Thank you, Mr. Marais. Then there was a question that was put to to Professor van Staden regarding the recent politically infused judgments that came out of our courts. And without now putting him on the spot, but I know these judgments had significant impacts in the lives of ordinary South Africans, and also South Africans would have like a certain view about the judge that's sitting on the case. But I'm so glad that my colleague, Mr. Luthuli, indicated that people bring matters to courts, not the judges. But I would leave it over to you, Professor van Staden.
Thank you so much. As you may have realized, we've lost the lights in the room. Nevertheless, I think we can proceed. And first and foremost, what I would like to perhaps counter the question with is with another question, and that is, what is wrong with the court being political? The Chaskelson Constitutional Court was in fact very political. The mandate that the Constitution imposed upon the judiciary was to be political, right? Transformative constitutionalism cannot and could not occur without judges entering into the domain of politics. But I do think that the question is very, very important, especially within the context of a constitutional court, which I believe has become more conservative actually in the last couple of years. I just quickly looked up the recent case that was handed down by the Constitutional Court about 2 years ago, in which the Constitutional Court in the Rafeneke matter said that, in fact, you had to be a permanent resident of the country to become a legal practitioner, so as to do articles. That case, which I've written on a previous occasion, to my mind was very shocking. It's the type of conclusion the Constitutional Court had reached, that the original Constitutional Court, the original Chaskelson Constitutional Court, would never have reached in really a jurisprudence that was meant to protect the most vulnerable in society. And I think our Constitutional Court has unfortunately started to fall short of that mandate. So yes, to answer your question, I think maybe what we need is a Constitutional Court that becomes a little bit more political. Thank you, Chair.
Thank you, Professor van Staden. Then I would move over to Mr. Luthuli to actually respond to the question that was posed by one, I think it's a young graduate that is actually looking up to him as a role model and say, what do the legal practitioners that's already made it, that has been successful in their different spheres, to actually open up opportunities for younger guys, creating, I think, maybe mentorship type of situations for them?
Thank you for that, Mr. Hart. I think it's a question that is very close to my heart, at the heartbeat of my practice. I recently was honored to address a group of BLA students from UJ. That's how I spent my Freedom Day, talking about access to the profession. And the concept of mentorship came up very strongly. I've mentioned my mentor, and ever since being mentored by him, I understood the concept of bringing down ladders. I understood the concept of sponsorship, which is beyond just mere mentorship. And I think our profession historically comes from an elitist profession. It used to be aloof. Being a lawyer was your preservation, and really you're not interested in raising other lawyers. And a generation is rising now that's interested in opening up the profession and saying that if I could do it, you could also do it. There's a lot of collaboration between practitioners and students, certainly without promoting my law firm, but it works quite closely with the Faculty of Law here at UJ, where we sponsor students through bursaries, and also we take those students through mentorship, ultimately the view of taking them for articles. That's very crucial. So the first tip to that question would be find a mentor who's within the profession, and it doesn't have to be the area that you're interested in, but someone who you can look up to so that you can unlock the profession and access it. Secondly, before even looking for articles, have a relationship with a law firm where you do vacation work, because it's easier when they're looking for article clerks to know you because you've spent some week or 2 weeks under their shadow. And I think it's very important to identify those firms. And I know most of us will congregate towards a certain class of firms, but any other law firm will give you that particular exposure. Some smaller one can even give you bigger exposure because it's more intimate. So that would be my advice to students. Just get a mentor and they will unlock your access to the profession. Thank you very much, Mr. Hart.
Thank you, Mr. Luthuli. Then there is a question that speaks to South Africa as a rich tradition of customary law. How do you see the legal system integrating and respecting customary law principles while upholding the constitutional guarantees? And that question I can pose now to any of the panelists, because it's so wide, it's so open, and anybody, anywhere can, with some legal background, would know how to actually answer that. But I don't know who wants to take a pick here, because I believe everybody has got a chance. I don't know who wants to take the first step.
I see Prof. van Staden is
hinting at you.
And I'll gladly take the question because I had the absolute honor of appearing as one of the counsel in the Sekau 3 case that went to the Constitutional Court in November last year. And I say Sekau 3 because it's gone to the Constitutional Court 3 times. That particular case concerns, the rightful heir to the Amapondo throne. But the length and breadth of the litigation history in that case is very much centered around customary law. And our leader, Advocate Jeff Budlander, is a real forerunner in that area in particular. And he argues that customary law is living. It's not something that is static. It's not to say that in 1800, this is how we did things and we're never going to do it any different. Unfortunately, colonialism and apartheid and all of these interruptions to Indigenous life created a situation where we felt like customary law was frozen in time. But customary law, like any other law, evolves. And in a country where we have constitutional supremacy, that customary law must evolve in line with the Constitution. And I don't think anyone can argue that the Constitution would be disrespectful of customary law if we take into account that the primary basis of law is to create a harmonious society where people have rules of engagement within which they can exist together in harmony. So, for example, when we talk about the place of women in customary law, that has fundamentally changed under the Constitution, but it had to. And as much as it had to, society has changed. There was a time when women couldn't read, so you would never be able to know if I was intelligent or not. But now women are able to become, as qualified as men. For customary law to remain in a static position where we still view women as infants would just not be conducive to a harmonious society.
Thank you. Professor Staden, I see you nodding when Advocate Mutemwa is speaking, and I'm 100% sure you've got something to say about this.
I just think that, Mr. Hart, we've a lot of work to do still. Quite often when we speak about customary law and especially values that exist within customary systems, we only speak about Ubuntu. I think what we've done is we've sort of created a caricature of what Ubuntu is and what it means without fully engaging with it. I say so generally because there has been authors like Ramose that has done a lot to actually even showcase Ubuntu as an export product, not only for South Africa, but for the world, right? But there are also so many other values that exist within customary law in our society that we haven't explored yet, and that may in fact exist as public law or as constitutional values, I would submit. So yes, I agree, it's living law, but there is scholarship needed. And we need a generation of scholars that would take up this task and fly the banner to develop a truly South African system of law.
Thank you, Mr. Chair. Then I would want to pose a question to my two other colleagues, and I would start with Mr. Luthuli and say, how is the justice, or how is looking at what are the most pressing legal challenges that our democracy faces, and how can they be addressed? And I want my colleague, Mr. Marais, also to come in on that point, but I would go with my colleague, Mr. Luthuli, first to say, what is the most pressing legal challenges? And the reason why I'm asking you is because you sat on the bench, so you could see the thing that flows through the doors of courts.
Thank you, Mr. Hart. One of the things that the judiciary is facing is the public perception, which is dwindling, the confidence that people have as litigants to the courts. One of it is brought by the concept of lawfare that I've alluded to, where political questions are brought to court for settlement. And of course, the party that is not happy will be aggrieved and starts condemning the courts for being in favor of one over their own case. And I think that is the trappings either of the media by actually misquoting judgments and taking one line and taking a populist narrative as opposed to contextually explaining what judgment was and what was the decision of that particular court. And I think it's very important to study jurisprudence, not on just like a fly note that flies out there out of context. Because judges don't have an opportunity to speak to the public and defend their judgments. They can only speak through judgments that they hand down, and they can't stand and defend that in particular in public. Number two, it is the problem of still an issue of transformation where people still feel foreign to the courts that they're in, the issue of alienation. They don't see much people that they could. There's significant progress, but we still need to go further insofar as transforming the judiciary. I chuckle when my two colleagues talk about customary law, because there's another counter narrative that's going around, whether our courts even the best arbiters to settle customary law issues. I chuckle at the irony, for instance, of the Zulu king, who is supposed to be the custodian of all things Zulu, having an all-white counsel from the attorney to the advocate. What is he saying about the Zulu people and the capability, you know? And all the scholarship that's around the need to go back to customary law and say, can we have a whole judicial system that arises out of customary law that does not run parallel to the courts, because it has a constitutional imperative, which is customary law. So I think there's a lot of work to be done. Judges are becoming, they are descending to the arena of politics because legal arguments that are brought to them are political, and therefore they have to answer politically. Judges are not some people sitting in the same council pie in the sky somewhere, unaffected by the world. Gone are those days where judges never read newspapers. Judges will read newspapers. Now, judges want to know what people think about issues that affect them. So I think a lot more needs to be done in our jurisprudence to bring also the movement of simple writing from judges. Judgment that are accessible in English, pure, simple English. Anybody can read the judgment. Judges used to write for an audience that is somewhere in Rome studying Latin. And the people who are supposed to be beneficial of the judge are sitting there and they're saying, what on earth is this judge saying? I read a particular case without lambasting any particular judge on an assigned services, important issue about labor brokers. We had to sit with an Oxford dictionary to understand every single paragraph of what the judgment meant. We couldn't understand. So let's be more accessible, and by accessibility, people like acting judges are starting to write judgments in Sotho languages. That is laudable. And that's more of that will be encouraged to encourage people to have confidence.
I want to actually, before I wanted my colleague to speak on this, but I see that there's something that actually right into his corner. The question that they posed here, technological advantages or advancements presents both opportunities and challenges for both the legal system. In our opinion, how well equipped is South African law to deal with issues like cybercrime, data privacy, and intellectual property in the digital age? And I think, Mr. Marais, you are, because you've been working on cyber law, I think you are best placed to actually tackle that question for us.
That is absolutely not a worry for me at all. We have been able to apply the law that we have to the cyber world very effectively. The newly created legislation is comparable to the best in the world, and the old myth that lawyers are opposed to the use of technology died during the COVID lockdown, when the legal profession moved to an online functioning far quicker and far more effectively than most any other industry in South Africa. The biggest challenge that our legal system on a practical level faces is quite simply budget. The state capture years eroded so much of the fiscus that directors general in government departments know very well what the challenges are, but do not have the budget and will not have the budget in the next 5, 10, maybe even more years to address those problems. So we have highly intelligent people doing an excellent job with the very limited resources at their disposal. And I want to take this one step further. And I feel we have to honor people like Mr. Hart and the work that he and his crew do in the law clinics and in the legal aid centers, because there is just an overwhelming overflow of people needing legal assistance. And I, having been in practice for 10 years, have done so much pro bono work that at one stage it threatened the very economic livelihood of my practice. But you cannot turn away people who are in need of legal assistance. So the big obstacle is a small little word, and that is budget. Thank you, Mr. Chair.
Thank you, guys. And I can see the chats. There's so many questions, but unfortunately, we do not have time to actually address all these questions. And I want to thank the online audience for actually the questions that they posted, the panelists, and actually for their participation. It was really wonderful to see the questions, and also my panel of guests. It was easy working with you guys, because you guys make it so easy. It's like I'm sitting and watching a 4-man movie as you guys are flowing with the answers. And that just made my job, like I can just sit here and look beautiful, and you guys did all the hard lift or the heavy lifting. And I want to thank you guys for that. But without further ado, and I apologize for the questions that we did not get to. Unfortunately, time is not our friend. We have limited time spaces to actually do these things. But I also want to bring into the frame my colleague and friend, Mr. Nell Ledwaba, to come and do the vote of thanks on behalf of the alumni division in our university, but also on behalf of our faculty.
Thank you, Mr. Hart. It has been an honor and privilege to have all our panelists on board. First and foremost, I wish to apologize to our viewers for the lack of lights, but I learned something today, that you'll never stop lawyers from talking even from So on that note, I wish to sincerely, from the bottom of my heart, thank all our listeners, our viewers at home. Myself being a lawyer and a law student, I really learned a lot. It was an eye-opener, and I wish that we can make a follow-up discussion on these prominent matters. And then secondly, I want to also thank our acting executive dean for having provided us with this space. We made this request within a short space of time, but certainly Professor van der Linde, she provided this space and all the resources that were required. We really thank you. And then again, our panelists, they took time to come here and share with us their legal minds and opinion about this prominent matter. I wouldn't name them one by one, but they must be rest assured. We really appreciate and sincerely thank their presence this evening. And then I also wish to extend my thanks to the alumni and the faculty of law team, all the coordinators of this event. Without them, we wouldn't be where we are today. And then that also includes our technical staff at the University of Johannesburg. It's whether the technology affects us or not, but they still made sure that the discussion continued as it ought to. And lastly, our facilitator, Mr. Hart, I always see you on TV, but today I saw you in person. It's an honor. I hope I'm going to take a picture with you and brag. I'll have bragging rights when I arrive at home. And lastly, I don't know who's going to thank me, but I have to thank myself.
No. That one would be left for me.
Okay.
I would also want to thank you, Mr. Ledwaba, because I remember meeting you in the lift and actually telling you about the event, and you did not even hesitate 2 minutes. It was literally, we were at an event at the Madibeng where we currently are. We were at the event and we walked into the lift and I told him, Broer, what is happening to our alumni? Because we haven't been in contact with our alumni. And he said, don't worry, I'll send you an email tomorrow. He did not send me the email tomorrow. He sent me the email the same day. So I want to thank you for your active role, that you make sure that our alumni is always informed of what's happening in the great, and remember, the great University of Johannesburg. So guys, thank you, Mr. Ledwaba, and we're looking forward to engaging with our alumni, as I know he's going to go soon on various trips to actually make sure that we gather our alumni across the world, not just in South Africa, across the world. Once again, thank you, Mr. Ledwaba, and thank you to all the attendees online and also our panelists. I am proud to say that our panelists are all former UJ graduates. Thank you.
The University of Johannesburg, the future reimagined.